Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple and the SEC reached the final stage of their legal battle with the court set to decide on key issues. The SEC and Ripple Labs are at a crucial juncture in their ongoing legal struggle until Southern District of New York Judge Alyssa Torres decides the remedies for this significant case. The most recent court brief filed by the Securities and Exchange Commission SEC is the last statement. On May 20, 2024, the Securities and Exchange Commission SEC responded comprehensively to Ripple's request to seal financial documents and other evidence. In its letter to Judge Torres, the Securities and Exchange Commission expresses its vehement opposition to Ripple's decision to conceal financial data and contractual provisions that are essential to the court's treatment of the case. The Securities and Exchange Commission believes that public access to court documents is necessary for openness and accountability, citing the case of Lugos VIR Mid of Onondaga. The Securities and Exchange Commission places a strong emphasis on public access in public interest and regulatory enforcement procedures. Emphasizing transparency, the Securities and Exchange Commission CEO stated that the common law right of public access to judicial documents is deeply rooted in our nation's history. Ripple's request to conceal financial information and contract conditions is denied by the SEC, even though 5 items of documentation are sealed. For the purpose of evaluating compliance and fines, it is vital to have information regarding Ripple's financial health, recent XRP sales volume, as well as income and spending records. Ripple is being criticized by the SEC for lying about the following information. Through Ripple, the public can review the SEC. Since Ripple is unable to conceal information that supports its legal stance, the CC asserts that the company's public and legal views are incompatible with one another. Ripple asserts that disclosing financial details will hurt the company's ability to compete. In its response, the Securities and Exchange Commission SIG describes Ripple's assertions of relevance and sensitivity as being contradictory. Once an item is determined to be relevant to judicial power, the presumption of access must be based on the role that it plays in the exercise of Article I judicial power, according to the Securities and Exchange Commission SHIA. Additionally, the SEC makes note of the fact that Ripple is attempting to conceal old financial data, claiming that doing so will not impede the company's economic activities. The Securities and Exchange Commission SEBL emphasizes openness by stating that stale business records cannot justify the necessary finding of harm. Waiting for Judge Torres' decision is the cryptocurrency industry. Ripple is proposing a fine of $10 million, while the Securities and Exchange Commission is demanding a fine and penalty of $2 billion. The fact that Judge Netburn is tasked with determining whether Andre Fox is a summary witness or an expert witness before Judge Torres' decision could potentially make the situation more complicated. This lawsuit will have an impact on the Bitcoin industry. If Ripple is found guilty, it could result in the United States Securities and Exchange Commission regulating other digital assets. If Ripple is successful, the industry may become more robust in the face of regulatory challenges, and the state of digital currencies may be clarified. Ripple and the Securities and Exchange Commission have reached the final stage of their legal war, and the court is about to decide on critical issues. This item was initially published on Optimism. The United States Securities and Exchange Commission SEC and Ripple Labs have been engaged in a legal war that has escalated with the SEC in most recent court filing. This file marks the CC's final contribution before Judge Alyssa Torres of the Southern District of New York deliberates on the remedies phase of this momentous case. An exhaustive response was offered by the Securities and Exchange Commission CBR's filing dated May 2024 in response to Ripple's request to conceal critical financial papers and other information that is essential to the case. A resolute disagreement with Ripple's motion is expressed in a letter that was sent to Judge Torres by the Securities and Exchange Commission SEC. This resistance is particularly focused on the concealment of financial data and contractual provisions that are essential to the court's determination of appropriate remedies. Ripple's stablecoin is going to have a great impact on cryptocurrency and traditional finance. According to a leading economist, the opposition of the Securities and Exchange Commission is predicated on the principle of public access to judicial papers, which is a fundamental component of legal accountability and transparency. When it comes to instances that include public interest and regulatory enforcement, the Securities and Exchange Commission highlights the historical significance of public access. Citing the case of Lugosz v. Pyramid Company of Ondaga with support, the Securities and Exchange Commission makes a compelling argument in its brief when it asserts that the common law right of public access to judicial documents is firmly rooted in our nation's history. This assertion emphasizes the need for transparency for public scrutiny and confidence. Although it agrees to the sealing of 5 documents in their entirety, the Securities and Exchange Commission, the SEC, is not in agreement with the company's request to conceal important financial statistics in terms of contracts that were mentioned in the remedial deliberations. This includes information that would indicate Ripple's present financial health, the number of recent XRP sales, and the specifics of revenue and expenses. All of these details are considered essential for deciding whether or not the company complies with the regulations and determining whether or not any penalties may be imposed. A critical analysis of the reasons for sealings conducted by the Securities and Exchange Commission. Ripple invites the public to form opinions about the merits of the SEC's positions. The Securities and Exchange Commission made a statement that pointed out a mismatch between the company's public communications and its requests made in courtrooms. It cannot simultaneously hide from them the evidence on which that position is based, the SEC said. Ripple's most recent move strengthens its position as a digital asset custody provider, according to a related article. The competitive position that Ripple holds in the market could be negatively impacted by the public revelation of crucial financial details. According to the justification that Ripple provides for its request to have the information sealed, the Securities and Exchange Commission, on the other hand, responds to this by pointing out contradictions in Ripple's position regarding the significance and sensitivity of the information. In response to the assertion that the information that has been sealed is not pertinent, the Commission has stated that once an item is deemed relevant to the exercise of judicial power, the weight to be given the presumption of access must be governed by the role of the material at issue in the exercise of Article I judicial power. Ripple's present business activities are unlikely to be severely impacted by financial details from years ago, according to the Securities and Exchange Commission, SEF, which also adds that some of the information that Ripple intends to keep confidential is out of date. The Securities and Exchange Commission, C, asserts that stale business records cannot support the necessary finding of harm, hence bolstering its position on the necessity of maintaining transparency regarding outdated financial information. As the crypto sector waits for Judge Torres to issue her decision, they are keeping a careful eye on the situation. In contrast to Ripple's counteroffer, which suggests a potential penalty of only $10 million, the Securities and Exchange Commission has proposed fines and penalties that amount to approximately $2 billion. The stakes remain very high. It is important to note that the only stage that remains in the Rippleverse SE case before Judge Torres can give her final decision is for Judge Netburn to decide whether Andre Fox is a summary witness or an expert witness.